Hello, my name is Raymond Million. I'm an attorney here at PCT Law Group, and today I want to talk to you about intellectual property. Now, what is intellectual property? Well, intellectual property refers to creations of the human mind that are protected by federal and state law, very much like real property. Now, studies will show that intellectual property accounts for as much as 3/4 of the value of most publicly traded companies, and even a greater percentage of private companies. So let's go through the four main types of intellectual property: patents, trademarks, copyrights, and trade secrets. First, patents. Patents are a grant by the U.S. federal government to an inventor of a process, a machine, an article of manufacture, or a compound that is useful, non-obvious, and novel. Now, the term of a patent is 20 years from the filing date. And the power of a patent is that it allows the owner of the patent to exclude others from making, using, selling, and importing into the United States the patented invention. Now, for trademarks. A trademark is a way to describe the source of a product or service. That way can be a name, so as, for example, Nike for athletic footwear. It can be a symbol, sort of like the swoosh logo for Nike athletic footwear. It can even be a color, as in brown for UPS trucks, or it can be a shape, as in the shape of a Coca-Cola bottle. Now, in order to be granted a trademark, you must use the mark in interstate commerce, you must affix the mark to the product, or use it in conjunction with advertising for a service, and the mark must be distinctive. Trademarks are granted for a term of 10 years, and they're renewable as long as a trademark is in the actual use in commerce. Now, for copyrights. Copyright protects an original work of authorship that is fixed in a tangible medium. Copyright protects text such as software source code, such as music and the accompanying lyrics. It protects sound recordings, movies, poems, books, videos, sculptures, and paintings. Copyrights are often granted for the life of the author plus 70 years, or if it's a corporate author, 95 years from the date of publication. Now, on the trade secrets. Trade secrets are anything that grants the owner of that trade secret an economic advantage. It could be a compilation, such as a customer list. It could be a formula, such as the formula for Coca-Cola. It can be a recipe, such as the original recipe for KFC. Anything that's a technique, a formula, a recipe that's kept a trade secret, in other words, that it's not revealed to the public, but derives the owner some economic advantage, is considered a trade secret. And those four things, patents, trademarks, copyrights, and trade secrets, make up intellectual property. And the attorneys here at PCT Law are ready to assist you in securing your intellectual property rights and also monetizing those rights once they have been secured. Thank you.